Pranam, Jai Shri Ram, welcome back. In this third episode on amendments to Waqf Amendment Bill and the recommendations made by the Joint Parliamentary Committee, we will continue to understand recommendations beyond clause 32, which we had covered in episode number 2. So under clause 33, the committee examined the clause 33 and note that clause 33 of the bill seeks to amend section 72(1) relating to annual contribution payable to board, replacing the contribution to 5% in place of 7%, while in section 72(7) the words "and the decision of the board thereon shall be final" shall be omitted. In the context of the reduction in annual contribution to the Waqf board by the Muttawali of a Waqf property, the committee are of the opinion that with the proposed strict accounting and auditing of Waqf, the funds available with various Waqf boards even at 5% contribution would be reasonable, and at the same time the individual Waqf will have more funds at their disposal for pious, charitable and religious purposes. However, the committee do not rule out instances wherein a particular board may face financial crunch. The committee therefore feel that a flexible upper limit may be envisaged depending upon the financial situation of a board. Thus, the committee recommend the following amendment in clause 33A. A. In subsection 1, for the words 7%, the words 5% subject to a maximum amount as prescribed by the central government shall be substituted. Regarding the amendment proposed under section 72(7) pertaining to the omission of the words giving finality to the decision of the board, the committee note that it is a consequential amendment aimed at providing the aggrieved party with an opportunity to challenge the decision of the board, thus increasing the ambit of attaining justice. Hence, the committee decided to accept the amendment proposed under the clause. Clause 34. Committee note that the amendment proposed while clause 34 in section 73 subsection 3 omits the words "and the decision of the tribunal on such appeal shall be final." Viewers, please note in all the 3 episodes, 2 previous and third one now, you will find that a decision of tribunal which was final is now being struck down. The committee are of the view that such omission is a result of consequential changes to the proposed amendments in the bill regarding the creation of provision for appeal against the decision of the tribunal. Hence, the committee decided to accept the amendment proposed under the clause. Clause 35. Committee and stakeholders as well as the Ministry of Minority Affairs find that the proposed amendments, including declaration of any tribunal as Waqf tribunal, introduction of the provision of appeal to High Court directly, and change in the composition of the tribunal would expedite disposal of pending cases, considering that as many as 19,207 cases are pending in Waqf tribunals. Viewers, please note 19,207 cases are pending in various Waqf tribunals across the country. Thus, the committee endorsed the amendment proposed in the clause except for the provision relating to the composition of the tribunal. The committee are of the opinion that the composition requires revision to incorporate a member having knowledge of Muslim laws and also to make the tribunal a 3-member body rather than a 2-member body. The following amendments are recommended in clause 35. In clause 35C, in subsection 4 after point B, point C is inserted. One person having knowledge of Muslim law and jurisprudence be a member. The first provision in clause 35C under subsection 4 is omitted. In second provision in clause 35C, the word "further" after the word "provided" is deleted. Clause 36. Considering the high pendency of cases with the Waqf tribunal, the committee are of the firm opinion that the said amendment providing a timeline for settlement of disputes would expedite disposal of cases. However, the existing provision of the law states that whenever an application is made to a tribunal for the determination of any dispute, question or other matter relating to a Waqf, it shall hold its proceedings as expeditiously as possible and shall as soon as practicable on the conclusion of the hearing of such matter, give its decision in writing and furnish a copy of such decision to each of the parties to the dispute. The committee are of the view that in the existing section, ample emphasis has already been given to earliest disposal of cases by the tribunal. Therefore, it may not be necessary to fix a time period for the disposal of cases by tribunal accordingly. Amendment to Clause 36A is given below. Clause 36 stands omitted. Clause 37. Committee examined Clause 37 seeking to amend Section 91 of the Principal Act and agree with the replacement of referred repealed Land Acquisition Act 1894 with the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. The committee also accepts the amendment wherein any order passed under Section 77 or Section 78 of the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013 is not declared void if the board is not given an opportunity to be heard. Rather, the said order shall be kept in abeyance relating to portion of the property claimed by the board and assigning collector to hear the parties and make the order within 1 month. However, the committee, after hearing all the stakeholders, feel that the proposal to reduce the time period given to Waqf board to appear before the collector on receipt of notice of acquisition of a Waqf property from 3 months to 1 month would not be reasonable time for the board to plead to the proceedings under the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Hence, the committee recommend retaining the 3 months period. Accordingly, Clause 37A2 is omitted. Clause 38 of the bill seeks to amend Section 100 of Principal Act to substitute Survey Commissioner with Collector, as the duty of the Survey Commissioner have now been transferred to the Collector. The amendment regarding substitution of role of Survey Commissioner with that of Collector proposed under Clause 5 of the bill is acceptable to the committee. Proposed amendment under Clause 38 is merely consequential, hence proposed amendment is accepted as it is. Clause 39 seeks to amend Section 101 of the Principal Act as the role of Survey Commissioner has now been assigned to Collector. The amendment regarding substitution of role of Survey Commissioner with that of Collector proposed under Clause 5 of the bill is acceptable to the committee. The proposed amendment under Clause 39 is merely consequential, hence the proposed amendment is accepted as it is. Further, committee also suggests that Indian Penal Code 45 of 1860 mentioned in subsection 1 and 2 of section 101 may be substituted with Bharatiya Nyaya Samhita 2023. Clause 40 in view of the deliberation of various experts, stakeholders, Ministry of Minority Affairs, the committee, while concurring with submissions of the ministry, accept the amendment and find it congruence with the original legislative intent post-independence as well as in agreement with the proposed definition of Waqf, which requires the donor to a Muslim who has practiced Islam for at least 5 years. In view of the deliberations with various experts and stakeholders and submissions of various government ministries as well as those of the Ministry of Minority Affairs, the committee concur with the desirability of the proposed omission of section 107, 108 and 108A wide Clause 41 of the amendment bill, as these are necessary to reduce litigation, simplify process of recovering Waqf properties, thereby facilitating legal harmonization of Waqf Act 1995 with other laws and avoiding overlapping with the various acts. Notwithstanding the said desirability, the committee also empathizes with the concern expressed by multiple stakeholders regarding the potential of assertions of adverse possession resulting from retrospective applicability of the Limitation Act 1963 emanating from the current formulation of Clause 41. In this regard, the committee do take note of the assurances of prospective application of the omission of section 107 by Ministry of Minority Affairs. Thus, for removal of any doubts whatsoever, the committee have redrafted the proposed amendment as below. A new clause 40A is proposed as given below. 40A section 107 of the Principal Act be substituted, namely, on and from the commencement of the Waqf Amendment Act 2025, the Limitation Act 1963, 36 of 1963 shall apply to any proceedings in relation to any claim or interest touching upon immovable property comprised in a Waqf. Clause 41 is amended as given below. Sections 108 and 108 of the Principal Act shall be omitted. Clause 42, committee do not find merit in the submissions made by the Ministry of Minority Affairs that these amendments would improve the administration of Waqf management and hence accept the amendment. do find merit in the submissions. Clause 43, in view of the submissions of the Ministry of Minority Affairs and the fact that the proposed amendments are merely consequential, committee accept the amendment as it is. Clause 44 also, it considers that the amendments are basically incidental in nature and the board's regulation making powers in its substantial functions remain unchanged except for the two functions. Accept the amendment as it is. We now move on to the general recommendations. Taking cognizance of the issue discussed, the committee are of the view that the protection accorded to scheduled tribes and tribal lands under Schedule 5th and 6th of the Constitution must be upheld and any threat perceived or real needs to be addressed. The committee therefore recommend that the ministry should take appropriate legislative measures to forestall declaration of tribal lands as Waqf land in order to ensure protection of scheduled areas and tribal areas. It may be noted that in Chhattisgarh you might have heard of usurping of land belonging to tribal women by illegal migrants from Bangladesh who are marrying them, and because after marriage the property gets transferred to them and then they try to declare it as Waqf land. In light of the submissions made by the tenants associations regarding their long-standing association with Waqf properties, the committee emphasizes the need to address their concerns compassionately during the formulation of lease rules. Recognizing these issues will provide legal certainty for tenants association and establish fair oversight to prevent abrupt or unreasonable decisions by Waqf boards. Such measures will reduce uncertainty and ambiguity, mitigate the impact of sudden rent increase, and alleviate fears of sudden eviction. Furthermore, fostering a symbiotic and harmonious relationship between Waqf boards and tenants will ensure the prosperity of Waqf properties. The committee therefore recommend that the ministry may consider the concern of Waqf tenants across the country and introduce laws that allow for long-term leases to safeguard their legitimate rights. So, the bill for reference to joint committee. Now, these are various annexures which I will go when I take you back to the entire consultation process. In this third and final episode covering recommendations of JPC on Waqf Amendment Bill, you must have by now come to understand which stringent clauses of earlier Waqf Act and rules have been removed, where inclusivity has been brought about, where more broadened scope has been increased, and how this will by and large allay the fears and concerns of land grabbing by Waqf by user category as given to all the Waqf properties in the previous Waqf amendment bills up to 2013. So, I stop here now. If you like this video, please press the like button, to subscribe to my YouTube channel and also share in your network. Don't forget to press the bell icon to receive further updates. In the next series, we will go through the consultation process where each member of the Joint Parliamentary Committee, what they put forth their ideas and recommendations. Just to give you an idea who were the members of the Joint Parliamentary Committee. Let me take you through them. So this is a joint committee on the Waqf Amendment Bill. The chairperson is Shri Jagdambika Pal, and this was constituted in August 2024. Then these are the various members, Lok Sabha members: Shri Mohibullah, Shri A. Raja, D.K. Aruna, Kalyan Banerjee, Arun Bharti, Devarayalu, Nishikant Dubey, Abhijit Gangopadhyay, Gaurav Gogoi, Sanjay Jaiswal, Javed Mohammad, Dileshwar Kamait, Imran Masood, Naresh Gadpad Maske, Baya Mama Matre, Shri Asaduddin Owaisi, Dilip Saikia, Aparajita Sarangi, Arvind Sawant, Tejasvi Surya, Shri Mohammad Abdullah, Dr. Radha Mohan Das Agarwal, Shri Ghulam Ali, Shri Brijlal, Mohammad Nadimul Haq, Dharmasthala Hegade, Dr. Sayyid Hussain, Medha Vishram Kulkarni, Vijay Sai Reddy, and Shri Sanjay Singh. So as you can see, from serial number 22 onwards till 31 they are members of the Rajya Sabha, and from 1 to 21 they are members of the Lok Sabha. A quick recap on how this whole parliamentary committee functioned. These were the various sittings they had, beginning from the last being 29 Jan 2025. This is a long list, and the various topics they covered during each of their sittings. So as you can see, this has been going on since many months. I will take you to the last page. "38 sittings took place between August to Jan 2025. So first meeting after constitution of JPC was held on 22nd August. Furthermore, these were the various meetings held. As you can see, there are almost 38 meetings. Meeting schedules were being printed. Study tours. Study tours were also organized across the length and breadth of the country. Between 9th November to 11th November, 2-day study tour was in Guwahati in Assam, then later on in Bhubaneswar. Between 26th November to 1st October, 5 days they were in Maharashtra, Mumbai, discussing with various people, then in Ahmedabad, later on in Hyderabad. From Hyderabad they moved on to Chennai. Then they went on to Bengaluru and met hundreds of various associations and organizations. So substantial work was done. Reports presented. This report, which was tabled on 30th Jan, and there was a press communique only on 29th of August. So as you can see, this report is yet to be put to discussion and debate in Lok Sabha and Rajya Sabha. So I am bringing out to you what were the main recommendations. Subsequently, I will also be sharing in series of short videos the consultation process, and most important, which many people would be more keen rather than acceptance, is note of dissent. So if I can take you back to the main report. In the index page, notes minutes of dissent received from members of the joint committee. So this goes into more than 200 plus pages from 547 to 821. So in the next series, I will be taking notes, minutes of dissent received from members extensively, and then lastly, on the positive note, who all were for the positive framework to amend this bill and make it more inclusive and not draconian or labeled as a land grabbing bill for the benefit of only the Samuday Vishesh community. So I take a pause here. Thank you for being with us. Pranam, Jai Shri Ram.